Well, hello everyone. Welcome again to the third annual uh, August is Make a Will National Make a Will Month. I'm with my friend and sister. You hear more from her, Sandy Bozeron in South Florida. Y'all know how we do this thing. If you're watching live, give us a hashtag live and tell us where you're from. If you're watching this on the replay, give us a hashtag replay and tell us where you are from. Tonight, this is the second of this series. It'll be every Thursday going forward. We had a Tuesday night, but the rest of the series will be on Thursday night at 6:30 p.m. Central, 7:30 Eastern. But tonight, my esteemed guest and friend, sister, all the way from South Florida, Sandy Bozeron is a estate planning and she attorney, lawyer, attorney, however you want to use the terminology. She also does a little real estate in this and guardianship in this area. She is very knowledgeable, very helpful, has a servant attitude, servant mindset, love to help people, love to educate. Her background is in education. Then she shifted into law. So I'm honored and it's my pleasure to introduce her to some and present to others. Sandy, again, I'm looking forward to a great night tonight.
Look, good evening. Good evening. Thank you so much, Troy. Troy is the Chief Encouragement Officer, and he truly encourages me to make sure that we're doing programming like this as frequently as we possibly can. Just a reminder, August is National Make a Will Month, and all month long, we're going to be bringing you this content to talk a little bit about the importance of creating your will and what happens if you don't have a will. So I am looking forward to sharing some conversation with you all tonight. Please make sure you drop any comments or questions in the chat. We are broadcasting right now on YouTube, on Facebook, and on LinkedIn, I believe. So please don't hesitate to share your thoughts and comments as we go through the show tonight.
Yes.
All right. Turning it back to you, Troy.
Yes. So I'm trying to see. It looks like Sandy, so we're live. I'm live on LinkedIn, so which is great.
Yes.
I can see it now, but I can't see anything on Facebook. Let me do a refresh here. But anyway, so tonight,
Okay.
Sandy's going to do a little shifting. Yeah, it's popping up now. Sandy's going to do a little shifting tonight on this Make a Will Month, this estate planning program. She's going to tell us a little bit more about. We haven't done it kind of like this way. She mentioned it to us Tuesday night, kind of how she wants to dive a little bit deeper in this. And we're going to deal with some complex issues, especially family issues concerning estate planning. This is huge because whenever you have a death in the family, there's typically some type of issues or drama, and a lot of that could be solved with proper planning. So Sandy is going to address that tonight. If you got questions, please ask your questions. We'll be more than glad to address the question. So Sandy, back to you.
Right. So tonight, what I thought we would do is address some things that most of the folks who are going to view this video are going to be able to connect with in some way, shape, or form. And that's talking about the different circumstances when it comes to family. So when it comes to creating a will, and again, August is National Make a Will Month, so that's why we're talking about this. When it comes to making a will, one of the very first things that is covered is this concept of who your family is and what your intentions are for different members of your family. And as we all know, our family structures are very varied. Like for me, the bulk of my family is just my immediate family, right? I'm not married, I don't have children. So when I talk about my family, I'm talking about my parents, right? I have my mom, I have my stepdad. I'm talking about my brother, I'm talking about my nephew, I'm talking about my aunt. I may be even considering some of the extended family, like cousins and other aunts that are, aging at this point and may need some support at some point in time. And so I want to talk about these special populations of folks that we may have to consider when we are creating this document that we call a will or a last will and testament. And the first population that I want to focus on is the aging population. For those of us that may be helping aging parents, helping aging family members, we need to consider what their needs are at the same time that we're considering our needs in creating our will. Because what we don't realize is when we create these instructions that we are creating in our will, we're identifying important things that whoever is going to handle our final affairs will have to consider, right?
Right.
And so if you are married and have children, well, we know, first of all, we're dealing with the couple themselves and the children. But we also need to consider whether there is an aging parent that might live in the home or might live in a facility or might live on their own. We also may need to consider that aunt or uncle that lives on their own, that has no children, that has no other folks caring for them, because what you want to have in place is something to ensure that if you're providing care for these people while you are living, well, who's going to provide care for them when you are no longer? And so in considering the family structure in your documents, you may want to extend the thought beyond just my husband, my wife, my daughter, my son. You want to consider other folks who may be relying upon your care and support that may need some assistance in the event of your passing. And we're all going to pass away at some point in time. We don't know what that time will be.
True.
And looking at the way things are going these days, every time you blink, somebody else is passing suddenly. So we
True.
want to consider, okay, who is my family that I'm providing for? But also, who is the family that I need to consider and say, you know what, I'm creating my documents. I'm going to go ahead and check if my auntie has her documents done.
Right.
I'm going to go check if my uncle has his documents. I'm going to check my grandmother and see if she has her documents, my mom, my dad. Like, I'm going to make sure that the folks around me are working on these things as well, because I don't want to be trying to figure out what their intentions are in the event of their passing. I want to be comfortable and have some peace of mind knowing that they've identified what they want. And I'm also going to do the same in my documents, considering the other responsibilities that I may have. So sometimes we have to be very clear about the people that are involved in this preparation of a final or last will and testament.
Now, Sandy, I'm assuming that with you, this has came through a lot of personal experience. You've had personally, or through either your personal experience or through working with clients that you have seen and had these issues come up, and you want to be able to address these and share the insights that help others.
Absolutely. And it's funny because most of the reason that I kind of talk about these topics is not just because I do this work. I have an adult nephew who is autistic.
Right.
And he requires full care and support. Right. And so as I'm preparing certain final arrangements for myself, I'm not just thinking about myself because I don't have any children. Right. My nephew is the child in my life. And so I think about the things that he's going to need and the provisions that are going to need to be done for him in my process of considering my planning for myself. And so that's an important piece to consider. Also, part of the reason that I have these conversations is because I have lost two of my aunties due to sudden passing. Like, we didn't think that this was going to happen, kind of thing. Right. At least at the time that it did, right? They were still young. They still had years ahead of them. But, things happen in life. And for one of my aunties in particular, I found myself literally trying to figure out what she wanted. And that wasn't easy because there was no will.
Right.
There was no letter or information or instruction. And so I just had to think about who she was to the best of my ability and try to process what things she liked or didn't like. As a unit, my mom and I, we had to come up with some things and say, well, we know she wouldn't want to be cremated. Like, her personality doesn't align with that.
Right.
But we don't really know.
Yeah.
There's no way for us to know. We're just assuming maybe she wanted to be cremated, right? Also, thankfully, she had some planning in place. Even though she didn't have a will, she had she had beneficiary designations on her life insurance policy. So she had life insurance.
Hmm.
So thankfully that helped. And we were able to deal with funeral arrangements because there were funds for that. And she also left funds for a couple of family members. So there was a provision provided for by her through her beneficiary designations. But without that, you can only imagine we just have to figure it out and see if there were funds available, maybe in her financial accounts, or see if she had, some money tucked away. Old school folks, they may have some money under the mattress or tucked away
Right.
somewhere.
Right.
So,
Yeah.
we would have had to do the GoFundMe life.
Yeah.
If we couldn't find the money in order to take care of final arrangements. Thankfully, at the bare minimum, she had insurance. And so even without a will, we were at least able to handle the fundamental things that she needed. Now, when it comes to things like who she wanted to have her personal effects, like her furniture,
Hmm.
artwork, clothing, shoes, purses, jewelry, electronics. She had stuff that she had just brought brand new from, I don't know if it was Costco or BJ's or one of those types of places. She had all kinds of stuff that was like brand new, not even opened. We didn't have a clue where those were to go. The only thing we could do is divide it up amongst, whoever the family members were that were there helping out with clearing things out and doing those final things. But there was not much that we could do in terms of following her intentions. We just had to try to figure it out.
Yeah.
And so when I talk about this creating of a will, I'm thinking about layers. I don't just see it as a one transaction with myself and my client, or one transaction with, the husband or the wife or the couple. I'm thinking about the person that I'm referring to. I'm thinking about the extended family. I'm thinking about that neighbor that you probably live next to, and you guys have been living next to each other for years, and you care for each other and you support each other and you're each other's emergency contact. Well, maybe you each should decide to have some things in your documents to support that other person.
Okay.
If that is your sole, we all know folks that are on their own. There is no other family.
Yeah.
There are no other close folks aside from friends. And so because we know this, we need to consider, well, how does that fit into the scheme of me creating my documents? Well, it's an important piece because even if I don't have family, friends can also be incorporated into our document,
True.
right? So when I list family information, well, maybe I don't have other family. Maybe I have a best friend. Maybe I have a long-term partner. We never married, but they're my long-term partner. I got to include them because they're not going to be naturally included. And if you do not have a will, please understand that there is no provision for these life partners, cohabitating partners, girlfriend, boyfriend, the longtime friend that was living with me as a roommate. There's no provision for that if you do not leave those instructions in your will. So you may very well be living with somebody long term. Like I had a situation years ago. Somebody was living with another family member long term. That family member was caring for them and they had some money coming and all this other stuff was going on. And when the money came, they had already passed away. And guess what? That family member that was dishing out all that money, expecting something to come along, was kind of left in the wind because they were not the direct connection to that person. They weren't a direct family member.
Wow.
There were other family members that had priority. And unfortunately, they were kind of left in the wind. I think maybe one family member that was receiving from their estate got a little something and gave to them.
Okay.
But what they were actually entitled to, they didn't get because unfortunately, their roommate didn't leave anything in the will to say, I want this person to be paid, this amount out of my account, or they didn't say anything. They didn't have anything.
Wow. That's messed up, man, because like you said, you have the one person taking care, living in and taking care of that. Hey, Miss AKA lady speaking. Hey,
Hey there.
But that's kind of strange that the people that receive the money that probably I'm assuming that they didn't want to help or support and then want to kind of reimburse the person that did take care of the family member. It would only be fair. Hey, look, you took care of this person. You should get this money, or at least get reimbursed with the money.
Absolutely. And that wasn't really like the initial thought. I mean, eventually they got a little something,
Yeah,
but that wasn't the initial thought. The initial thought was, oh, well, it's what I'm receiving, what's mine. Even though they weren't around at the time that
right.
this person was living to provide care and support and compassion.
So I guess, Sandy, what I'm really hearing here is that it could be it could be complex if the person, maybe, let's say that if they have Alzheimer's or dementia and somebody's taking care of them, because they're not at themselves to be able to make decisions that's maybe be considered legal and stand up in court. But it goes back to, if the person is at the time that they start helping them, and they have a sound mind to start thinking about those things and putting those things in place, especially if you have someone that's taking care of that person, to make sure that person, the caregiver, is not left out. Because caregiving, one of the things that we understand is caregivers get burnt out because of finances, because of emotional and physical. And
Absolutely.
they need a break. They need the rest, and many times it's not always the case, and it can be very stressful for them.
I mean, absolutely. And oftentimes the caregiver is forgotten in the mix. So when you're caring for someone, especially if that person doesn't have the ability to make decisions for themselves anymore, you may be completely forgotten in the mix. And
Right.
guess what happens? That person passes away.
Yeah.
And then guess who shows up? All the
Right.
folks that weren't around to do anything, who
Yeah.
may have priority over you in terms of receiving the benefit of whatever that person had. And I think, Troy, you and I, years ago when we were on Clubhouse, talking about a lot of these things, I talked about the relationship.
Mm.
Your relationship doesn't guarantee you any kind of privilege or process.
Right.
Just because you're somebody's wife or husband or girlfriend or boyfriend or life partner or roommate, you're not guaranteed to be able to access anything. And it doesn't matter if the person while they were living were like, oh, I'm going to, leave this to you or leave that to you. Well, if they never did, then there's nothing coming to you.
Right.
Now, if you have a contract or an IOU or a promissory note or some other legal document, then even after that person has passed, you potentially could be able to collect, but that's not a guarantee because there is an order of payment when it comes to after someone passes away and using whatever funds they have available in order to pay any outstanding debts. There's an order of priority, and depending on what state you're in, there may be some differences in what the priority is. I'll tell you, in Florida and many states, if you have IRS debt or a hospital bill, or if you have child support or alimony, those things are going to be paid even after you pass away, potentially.
Wow.
Right? If you owe a mortgage, if you
Yeah.
have a construction lien or a contractor's lien, many times those things will end up being paid. Those credit card bills that people are like racking up bills. When you pass away, they're the first ones in line to
Hmm.
put their hand out to
Right.
say, hey, they owed me 800, they owed me 1200, they owed me 1500. So they're going to file their claims against your estate. And depending on how much you have in your estate, they might get paid.
Wow. Now, Sandy, you mentioned something. This kind of thought came to mind. So let's go back to the scenario. So if something is in writing, you have a more chance of maybe proving intent. You may be able to get some compensation or benefit. So two questions here. One, what if a person has a text message? That's a form of writing. And what if a person have a Zoom recording and that person stating that blah blah blah?
So I'll say this. There's no guarantees in this situation.
Hmm.
None at all. There's no guarantees that you're going to get paid, regardless of some of the things that you may have in place. Because first of all, it's a question of, is there any money for you to get paid from?
Right.
You know,
Right.
Florida has homestead protection
Mhm.
when it comes to real estate. So it's going to be a question of, is there any money to get from that is not protected or exempt? Also, there may be other creditors that have a priority over your debt.
Mhm.
So, you know, that could be an issue. Also, you know, you're trying to prove your case in that instance with these text messages and other items. That may involve you having to have another related case to be able to fight and prove your case before you can set that claim against the estate. So there are layers to this process that may be involved, depending on the type of documentation you have and, you know, the type of assets that are in the estate. Because there's just so many things that need to be determined before we could say, yeah, you're going to get paid or not.
So what I heard you saying, you said there may be a other case. So there may be a case, a sidebar case, to determine if the text message is valid or the video is valid.
Very, very possible, because you imagine this. Somebody passes away in your family, Troy, and you are handling the final affairs.
Mhm.
And someone comes along and says, hey, you know, so and so owed me $500 and
Right.
they sent me a text on such and such date. What's going to be your first answer, Troy? You're gonna be like,
Right. Yeah. No.
prove it.
Yeah.
You're gonna be like, nah, prove it. And you're going to have to prove that. So
Prove it.
it's not something that's just going to be automatic.
Right.
But it's also not to say that just because it's a text message or just because it's some other form of communication, it doesn't mean that it's going to be a no either. You know, it
Right.
very well may be that, you know, you have the ample documentation to deal with the situation, but it's not a guarantee.
Yeah. You're right. And I guess the old saying, that old legal term, preponderance of the evidence, falls on that person to prove that this is valid. Is not the courts, but is that person have to prove that themselves is valid. I remember you mentioned this, and it's kind of coming back to me. And you mentioned this when we first started. But I remember we had a discussion. I can't remember if it was on Clubhouse or if it was one of these meetings about the relationships. And
Yeah.
that's important. I want you to address that, talk about that, because I think that's where the everything, what's the word I'm looking for, blows up, falls through, is the relationships are not solid.
Right. So there's one thing that I always notice when it comes to folks in relationships, and I mean all types of relationships, whether you have a relationship that is established, you know, by a license, or whether you have a relationship that is established physically in person, whatnot. um Many times people assume, because they are in relationship with someone, that it automatically entitles them to a status.
Okay.
um you know, the way that you interact with your partner in whatever capacity, whether you're married, whether you're living together, whether you are sharing assets, like you are own property together or anything like that, has nothing to do with the legal process. Because ultimately speaking, when someone passes away, everything in their name on the date of their passing is going to go through a process. And what that process is going to be based upon whether there's a will or not, whether there are assets that are controlled by operation of the law, like things that have a title, real estate, bank accounts, investments, retirement, whether it's personal effects, you know, vehicles, boats, artwork, jewelry, you know, movable, tangible things that people can touch. So depending on what the person has on the date of their passing is going to kind of direct who has the ability to get access.
Mhm.
And for the most part, if you're in a relationship with someone where you are married, you've established a status under the law by contract.
Right.
And so there are some things that you're entitled to by nature of the fact that you are married, that you have this contract. If you are living with someone, the only thing that I would ask is, do you own things together, right? Is it joint ownership with right
Mhm.
of survivorship? Is it joint ownership where each of you has a 50-50 share? Is there some kind of, if I pass away, it goes to the next person, right? So there has to be something to say, well, does the relationship have some kind of legal connection? Is
Okay.
there an obligation in writing that will stand beyond the person's passing? Because if I live with somebody and they own a house
Mhm.
and my name is not on the house, when that person passes away, unless my name is attached to this property, or unless there's something in a will or some other document or a deed, the property is not mine.
Right.
So therefore, we're going to be looking to, well, who's the family of this person? If there's a will, we'll be able to find the instructions of what that person wanted to happen to their property. But if there's no will, we're not going to have to go according to state law. And as we mentioned in our first session, we're going down the family tree often, depending on what state you're in. You're going to
Mhm.
go down the family tree. You're going to ask, was the person married when they passed away? On that date that they passed away, were they married at the time? Did they have children of the marriage? Did they have children outside of the marriage? Did their spouse have children outside of the marriage? If they didn't have any of those things, or they didn't have any children, did they have living parents? If they didn't have living parents, did they have living siblings? Did they have nieces and nephews? Did they have aunts and uncles? Did they have... So we're going to go down the tree and see who is entitled.
And you
So
know,
the relationship itself is not going to completely control unless there's a legal tie.
right. You made me think about, and this is not for all carriers. So I have a friend of mine, this some years ago, and he wanted to get a life insurance policy on his brother. And the carrier said, why is the brother getting both adults, both, you know, they have to, in their right mind, state of mind, why is the brother getting a life insurance policy on the brother? And they declined the policy. What they came back and said, is there any, I can't remember the terminology, any legal um, relationship? Um,
Right.
did they have property? Did they have a business? Those was the two main ones. Did they have property or business? And they
Right.
did have property together. So the mother or the father left some property to them, so they both had property. So I could write the policy now because they had their relationship, but they wouldn't. And that and I'm not for sure if that's all carrier, but this particular carrier would not accept unless there was some type of I can't remember the terminology that they use. Business
But they
dealing.
were looking for some direct connection between these
Correct.
folks.
Yes.
Because
Correct.
who goes and gets a random, like a policy on somebody unless there's a reason?
Correct, 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 correct. And that's the reason why, like you said, who gets the policy, and you can't write a policy on any and everybody. And some policies, if say grandchildren, you have to get the parents' permission to write the policy. If it's an IUL type policy, you have to get the grandparents' permission, the parents' permission. If the grandparents are the owner and paying for it, they still have to get the parents' permission to do that. So
For sure.
so those ties, so those relationships. So I kind of see what you're saying even more now. Is it doesn't guarantee anything until you start looking at the legalities and what they have and what that property, however it dictates if it's something in writing.
Absolute. Absolute. So as we talk about the relationships that we have that affect the way that we can make our will, again, August is National Make a Will Month. We're talking about the different things that impact your ability to create your will and the different things that you should be considering as you're, organizing your affairs and putting your information together. So when we think about relationships, we have to think about what binds people. And if there's not a legal binding document that connects you to someone, then when it comes to establishing your will, you're going to need to consider a few things, right? Because if I am married and I purchase a property with my spouse, I can't just up and give away that whole house to somebody else
Right.
in my will,
Right.
because my spouse is also an owner of that property, joint,
Right.
right?
Sure.
So
Yeah.
there are some things that you have to consider. If you own property in Florida, there are homestead protections. And oftentimes you can't just go ahead and put in your will, I'm going to leave this property to, my best friend when you have a minor child, or if you have a surviving spouse. You have some things that you have to consider and make sure that your state provides, the opportunity for you to do certain things in your will, because
So,
creating a will is a
hold on.
state specific thing.
Now back up. Something really caught my attention that you just said. Hold on. So first of all, let me say this: if you're watching live, do us a favor, give us a hashtag live and tell us where you're from. Thank you for joining us in August is Make a Will Month. If you're watching on the replay, give us a hashtag and tell us where you're from. So Sandy, person has a minor child, state of Florida. Person has a minor child, and they have property. They can't leave that property to someone else. It has to probate to the minor children.
So let me make sure I do my legal disclaimer. This is not legal advice. I'm not your attorney. The advice that I'm giving right now is just general information for educational purposes only. So please make sure that you find your attorney, because I am not your attorney.
Gotcha.
So here's what I will tell you. I will tell you that there are some considerations that have to be had before you think that you can just will your property to others when you have minor children, when you have a spouse. Okay? Because under different state laws, there may be protections in place for spouses and children.
Okay.
And so it's not to say that these things are impossible and you can't do them. It's just to say that there may be some issues with doing those things, because each state has certain laws and regulations in place that may prevent you from transferring your property if you do have special relationships in your life.
Okay.
So I will say that, because I don't want to give, a blanket absolute yes or an absolute no. But I will say that when you are crafting the language of your will, which is an important reason why you should consult with an attorney and make sure you sit down with someone to understand what's going into this document. But when you are creating this document, it's not just I'm putting my intentions on paper and it's all golden, stamp it, notarize, whatever, I'm done. Everything is going to come through the way I've written it. Absolutely not. I've seen people draft a will that says, I want to leave this property to my daughter. And by the time they pass away, there's no property. They've sold the property already.
Okay.
Well, guess what? I left in my will a specific property that I wanted to go to my daughter. But if that asset, the property, no longer exists at the time of my death, then I've now left nothing to my daughter. So if I go and buy another property, that's not what I listed in my will. Now, if I say I'm going to leave any property that I own to my daughter, different statement.
Gotcha.
So language matters.
Right.
So it's very important that we understand the way that these documents are prepared. Consider the different issues that we are going to face in these types of situations. So they're not simple transactions, and we have to be very careful about how we prepare these documents.
So for those that listen in, and I want to take a station identification break, a little pause here. This is one of Sandy's favorite quotes that she says, "Our lives are not filling the blanks." So when we're crafting these documents, we need to have some thought and some guidance with an attorney, so we can make sure everything is proper, because the issue won't come up until when we pass and they have the document, and that's when the issue comes up that has to be addressed. And when a person is passed, we're not there. If it's me, I'm not there to express what my intention was or what my desires are. So,
absolutely. So we've talked a little bit about, special individuals in our lives, our aging parents or aging family members. We've talked a little bit about relationships and, when you have a marriage or when you have, children. I also want to talk about some special situations as well. One thing I know is that a lot of families have, someone that they're caring for that has some type of disability. In my family, my nephew is autistic. He's nonverbal or non-speaking. He does require, round the clock attention and care. He uses a device to communicate. There are some special things and needs that he has that when we are crafting our documents in order to identify what the needs are, we also have to prepare some special information to potentially attach to our documents or include in our documents to make sure that whoever is responsible for his care moving forward understands what his needs are. And so for those who have a child, whether they be a minor child or an adult who has some type of special need, it's very important that you consider, in addition to just setting up your basic will information, that you also need to prepare for the fact that someone else is going to be needing to provide care to your special needs child, minor or adult. The manner in which you put this information together is all up to you. I mean, there's some things that you could definitely include in your will, but you may also want to have some itemized information about, where your child goes to school,
Okay.
what physicians they see, what medications they're taking, what their routine is, what they use, like devices, or if they have any, issues with texture or types of food, if they have allergies, if they are connected with any specific people or caregivers, if they have any special programming or special activities or special therapies or treatments. Those are things that you're going to need to very much identify, some of which you could probably incorporate into your will, but much of which you may have to have some supporting documentation that you're going to include wherever it is that you place your will, to make sure that you are protecting those special needs that you've been caring for some time. And so I always want folks to think about the special populations in their lives. And I'm not just talking about somebody who has some kind of disability, whether physical or intellectual or emotional. I'm also talking about folks who become incapacitated due to different conditions like dementia and Alzheimer's, et cetera. Many times those individuals also exist in this special needs world because they now require either round the clock care, special medical care, special caregiving. And so the things that you are needing to set aside, not only for yourself in your documents, you also need to consider leaving some information for the next caregiver, right? Because
Right.
you don't want there to be a drastic change between the care that you provided and the care that is needed by this individual in your life. You want to make sure that this person has a continuity of care and that they are not going to suffer, in the event of your passing, but instead that they're going to have some support that is as close as possible to what you were providing.
Sandy, can you, and I know this is Will, can you touch a little bit on uh, special needs, especially uh, that receives assistance from the government and
Absolutely.
leaving, maybe they have an insurance policy and they're leaving funds, it could affect their government assistance. And so, will you just talk a little bit about that? We have to be careful with that.
Absolutely. Many times folks will create trusts. And within their trusts, they may incorporate certain provisions like special needs trust provisions. And what that does is, if you have a loved one that is receiving, federal public benefits, and you want to protect their receipt of those benefits, you want to make sure that they can continue to receive those and they don't have any issues with eligibility. What is important is that you protect any funds that you're going to leave for them. So if it is life insurance, for example, it's very helpful to have a tool like a special needs trust to make sure that there's certain language in place that allows, for them to receive their benefits to provide for their, day-to-day care and needs. But then you have this trust that is able to receive the funds that will be used for their health care, their health, their maintenance, their, education, their activities of daily living, like their special treatments and special care and travel and other needs that they may have, so that they can still get the benefits to get their essentials, but now they also are able to receive funds that can provide for their long-term care and not be excluded when it comes to eligibility because of the receipt of additional funds. Because we know a lot of these government program funds have very specific restrictions about how
Right.
much you can have in your account at any given time, how much you can get received per month. So if you're going to receive a lump sum from a life insurance policy, that's not going to be very helpful. That's going to be an eligibility buster right
Yeah.
there. So
Right.
you need to make sure that if you are having someone in your life that you are trying to provide for long term, that you work with the proper professionals to make sure that you may have certain devices in place so that when they do receive funds, it is not in excess of the amount that they're allowed to receive. And sometimes I see people have certain annuities and other things too. So there are a lot of different tools that will allow you to accomplish these goals of making sure that your special needs, your family members with special needs are provided for on the long term.
Yeah. And I mean, excuse me, we commend, a person who's setting something up for the special needs of a person to leave something, an inheritance. But you want to make sure, that they have everything in proper place so it won't affect that eligibility. And I think sometimes
Correct.
because of lack of education, some people don't realize that, and they end up hurting their special needs person because of that. Sandy,
Absolutely.
I know we try to keep this around 45 minutes. And so
Yes.
if you want to give your final thoughts, wrap up, and then also tell them, you didn't tell them last time, but tell them how they can find you and locate you. And remember, y'all, she only practiced in Florida, but she can be a great resource. If you need someone out of state, she may be able to help you to find somebody else. Go ahead, Sandy.
Absolutely. And I work with a network of colleagues. So, because I can't take everybody. So, there are little things that I can work on, but there are a lot of things that I kind of outsource out. So, here on my YouTube channel, if you're watching here on YouTube, the description has my contact information. You can also find me online at spectrumlawflorida.com. And, those are the two easy ways to reach me here on YouTube, Spectrum Law, and as well spectrumlawflorida.com. So those are two easy ways that you can reach me. Just a side note, just to remind folks, we're doing this series all month long. I'm going to put it up on the screen. Today is August 14th. We have two more parts to this webinar series. So we hope that you'll join us same time, same place. So 7:30 Eastern, 6:30 Central. We'll be talking about what happens if you don't have a will. And we want to make sure that you are able to identify some of the different issues that need to be considered to make sure that you understand why it's important for you to have a will, especially as we're talking about August being National Make a Will Month. So tonight we talked about relationships. We talked about specific things that you need to consider, whether it be aging family members, minor children, marriage, cohabitation, relationships. We also talked a little bit about considering special needs and special populations and some things that you need to consider as you decide about preparing your last wishes or your last will and testament. So in continuation with the series, the next two sessions, we'll talk about certain specific assets, and we'll also talk a little bit about what are some pieces of information that you need to organize before you make a will here in the month of August.
Awesome. What you need before you even make the will. So it's some prerequisites and preparation before you even make the will. So
Correct.
Sandy, again, I appreciate you taking the time out of your schedule. You don't have to do this, but y'all that just listening and watching, Sandy has a heart to be a blessing to people and to support people. So make sure you follow her on YouTube, subscribe to her YouTube channel, support her, reach out to her. We want to let everybody know, meet us next Thursday, 6:30 Central, 7:30 Eastern. Looking forward for Sandy to share with us some more insightful and great information on this estate planning and Make a Will Month.
Absolutely, guys. So thank you so much for tuning in. We look forward to chatting with you guys again. I'm going to put it up on the screen again so that you know we'll be here on Thursday, August 21st and Thursday, August 28th. And thank you so much, Troy, our Chief Encouragement Officer, for encouraging me to do this yet again this year, third time in a row. I love it.
Awesome.
All right, guys. Have a great night. Hold on, Troy.
All right.